In this next video of the lesson, Documentation Policy Condition 2, we will learn about the second part of Special Policy Provisions and Endorsements, that is, assignment. The term assignment ordinarily refers to transfer of property by writing as distinguished from transfer by delivery. On assignment, nomination is generally cancelled except when assignment is made to insurance company for a policy loan. The assignment of a life insurance policy implies the act of transferring the right, title, and interest in the policy from one person to another. The person who transfers the rights is called assigner, and the person to whom the property is transferred is called the assignee. One of the important provisions mentions that the assignment requires the parties to be competent to contract and is not subject to legal disqualifications, and the assignee should not be eligible to get a claim that for some reason is rejected to the assured. There are two types of assignments. First is conditional assignment. It states that the policy shall revert back to the life assured if she is alive till the date of maturity or on the death of the assignee. Second is absolute assignment. It states that all rights, title, and interest which the assigner has in the policy are transferred to the assignee without reversion to the former or her estate in any event. Absolute assignment is more commonly seen in many commercial situations where the policy is typically mortgaged against a debt assumed by the policyholder, like a housing loan. Let us now look at the conditions that are necessary for a valid assignment. First of all, the person executing it, that is, the assigner, must have the absolute right and title or assignable interest to the policy being assigned. Secondly, it is necessary that the assignment be supported by valuable consideration, which may include love and affection. Thirdly, it is imperative that the assignment is not opposed by any law in force. For example, the assignment of a policy to a foreign national residing in another country may contravene exchange control regulations. And finally, the assignee can do another assignment but cannot do nomination because assignee is not life assured. Now let us compare nomination and assignment. Nomination is defined as the process of appointment of a person to receive the death claim, whereas assignment is defined as the process of transferring the title of the insurance policy to another person or institution. Second, nomination can be done either at the time of proposal or after the commencement of the policy, whereas assignment can be done only after commencement of the policy. Third, nomination can be made only by the life assured on the policy of his own life, whereas assignment can be done by owner of the policy either by the life assured if he is the policyholder or the assignee. Fourth, nomination is applicable only where the Insurance Act 1938 is applicable, whereas assignment is applicable all over the world according to the law of the respective country relating to transfer of property. Fifth, in nomination, the policyholder retains title and control over the policy, and the nominee has no right to sue under the policy. Whereas in assignment, the policyholder loses the right, title, and interest under the policy until a reassignment is executed and the assignee has a right to sue under the policy. Sixth, in nomination, witness is not required, whereas in assignment, witness is mandatory. Seventh, nominee has no right over the policy, whereas assignee gets full right over the policy and can even sue under the policy. Eighth, nominee can be revoked or cancelled at any time during the policy term, whereas the assignment once done cannot be cancelled but can be reassigned. Ninth, if nominee is a minor, an appointee has to be appointed, whereas if assignee is a minor, a guardian has to be appointed. 10th, in case of nominee's death, the rights of the policy revert to the policyholder or to his or her legal heirs. Whereas in case of conditional assignee's death, the rights on the policy revert to the life assured based on the terms of assignment. Though in case of absolute assignee's death, his legal heirs are entitled to the policy. 11th, if the nominee dies before settlement, policy amount will be payable to the legal heirs of the life assured. Whereas if assignee dies before settlement, policy amount will be payable to the legal heirs of the assignee. And 12th, creditor can attach the policy which has a nomination in it. Whereas creditors cannot attach the policy unless the assignment is shown to the creditor's defraud. Thank you.